Yo, what's good, everyone? I appreciate all y'all for tuning in. I had to check to make sure everything was the audio visuals was good. I appreciate y'all for tuning in. I'm Marcus here. We do attorney reactions to trending news, current events, and I actually jumped on and did this live off of Humble for two reasons. One, an interesting story popped up on my YouTube feed, and two, I thought about it. I may not be able to do a live tomorrow. So I was like, you know what? I'm going to do an impromptu live tonight. We're going to get it. It's going to be interesting. And the best part is here at this channel, we strive to be objective and fair. We talk about stories from both perspectives. Even if I feel a certain way about a certain side, hey, we just gonna give y'all the opinion it takes and whatever legal nuances that we can identify in the stories. But this is a good old fashioned flambe session. We get to do something that I kind of really like doing is a little bit, hey, I'm like 93% objective, 7% petty. And with that, this is going to be a good flambe session. We're going to focus our attention in this video. We're going to try to keep it short, but we're going to focus it on attorney Max Solomon, who may be the worst attorney that I have ever seen with over a decade of experience. It's actually pretty interesting. I don't know if I don't know. I don't know. I don't know what he's been doing this entire time, but we're gonna dive in and talk about it as always. Like, share, subscribe, comment if you want to. Hey, help out the channel. It's free to do that stuff. And hey, even if you hit the dislike button, it's all cool. It's all fair game. Shout out to everybody in the chat already. Hey, I see y'all. I appreciate y'all. Where are my buttons at? What the hell? Oh, okay, okay. I was like, where are all my buttons at? I wanted to give y'all a round of applause. And I couldn't give y'all a round of applause, but now I see it. So shout out to everybody in the chat, Prima Donna Bridges, Pretty Eyes, what is good, sis? Hey, my guy, Kenneth Dawkins, shout out to you. I was actually going through I had to go through some emails. I actually had to watch an old video to find an article that I talked about in the video that identifies something that we're going to talk about. What's going on? Appreciate you for tuning in. Shout out to Norfolk VA. Hey, let's go. Let's go. Let's do it. I got like old Redskins gear that I might break out, like my Sean Taylor jersey, my Daryl Green jersey. I might break all that stuff out at some point in time. But I appreciate everybody for tuning in. Loud Room Reacts. Hey, I appreciate you for tuning in, chiming in. Super Bowls a Sunday. Nah, see, you know what? I tried to leave your Detroit Lions comment out of it. I was going to specifically highlight your comment, but you are going to just have to learn the hard way. And shout out to you because hey, you are a official family member to the channel, but you a hard headed family member. You talked a little shady during the Detroit game. So hey, I'm gonna circle back and I'm gonna go live stream after we win the game. If we lose the game, we might have to skip next week's live stream. Well, nah, the Lightfoot report coming out Monday. Damn it, we'll figure it out. But we aren't gonna lose. I'm feeling confident. Let's go. Hey, it's all good. I'm not gonna hold your misguided football selections and ideologies against you. Still got love for your family. All right, so let's go ahead and dive in. We're gonna jump into Max Solomon, then we're gonna talk about the legal uh, bitch slap that he got by the court. And I just want to highlight something because as soon as I saw it, I was like, this is interesting. This is a pattern. So the very first thing that we need to pull up is the older story we did. We're not going to go through the whole thing. I'm just going to read the summary and some of the lowlights because I don't know if there's any highlights. But we are going to jump into this document right here. Now, for those of you who are familiar, y'all already know what this document is. This is before the hearing board for Illinois attorneys, and this is reference to our guy McSteven Osagun Adwale Solomon, aka Max Solomon, aka Can't Get Right. So I'm just giving him a new name. But let's just read the summary of the report, and then we're going to read the aggravating and mitigating factors, and then we're just going to move on right into the headline story. All right. Summary of the report. And this is 2023, if I'm not mistaken, that this order was issued. Okay, so let's go. A summary of the report. The administrator charged respondent Max Solomon with failing to communicate with and diligently represent a client in a mortgage foreclosure matter. If you all aren't aware, he essentially took on a case that he didn't get any compensation for, and his work was commensurate with his compensation. He didn't get paid shit, so he didn't do shit. He didn't get paid anything. He didn't do anything. Hey, that you get what you pay for. But he again failed to communicate and diligently represent a client in a mortgage foreclosure matter, dishonestly holding rental income that he collected on behalf of the client and should have paid over to her, and dishonestly converting a portion of that rental income from the client. The hearing board found that the administrator proved by clear and convincing evidence that respondent neglected his client's matter, failed to communicate with his client, and dishonestly converted $12,400 that should have been safeguarded for his client. For this misconduct, it is recommended that respondent be suspended for 1 year and until further order the court stayed after 6 months by 1 year period conditional probation. Now, again, this hearing was held in 2022. This is for conduct that occurred a long time ago. I want to say 2012, if I'm not mistaken, because he and I got about the same amount of time in the game. Yep, respondent was licensed to practice law on November 1st, 2012. Yep. So he had a client. He didn't do anything. The case got handled terribly. She had a judgment against her. He didn't notify her of anything. It's pretty much a shit show. He took money from a client. It was just all the things that you don't do. I'm actually shocked because normally you can do a lot of things. I know attorneys who got caught like with drugs in the car, with firearms in the car, and they can still practice. But generally, when you do something to a client's money, it's did not pass go, did not collect $200. But let's scroll down because we want to look at the aggravating factors and the mitigating factors. What the court considered when they said, you know what, let's give this dude a punishment, but let's not take his license right away. So much. Man, there's so much in here. This thing was 30 something pages. Let's see. Where are we? All right, recommendations, prior discipline. All right, evidence and mitigation and aggravation. So y'all can get a picture of what this is. He graduated in 2012. He ended up getting a job, and at that job, I think it was at a local or community college. At that job, he decides to do someone a favor and represent them in a foreclosure matter. I'll link the video where I went through this whole thing so y'all can see what it's about. Long story short, he didn't do absolutely anything. He didn't go to court. He didn't inform his client of what was going on. Client got hit over the head with a shitload of money. He collected rents on behalf of the client, misappropriated those rents. This was all from like 2012 to 2015. Now, you're going to ask, well, why are they just now making this decision in 2022? Because it was old conduct that didn't get brought to their attention until relatively recent. So one of the reasons he actually was able to keep his license, and we're going to hear them talk about that, is because he was so new. He didn't have a mentor. They just chalked it up to, let's say, inexperience. I was going to say stupidity, but no. When you're green, you don't know what you was doing. My first year too, I was making mistakes, not crazy as this, but we all make mistakes. You got to learn and curve. So they say, you know what? He made these mistakes. And even though we're looking at this in 2022, we got to understand this conduct was back in 2012 to 2015. And he didn't know his behind from a hole in the ground. So they gave him a little bit of deference. So in mitigation, the respondent, Solomon, testified that at the time he undertook his representative, it was his first year out of law school and he was just trying to help his boss. He testified that he had learned a lot since then. Did you Did you learn a lot since then? Okay. He testified that he learned a lot since then and he is willing to learn more. He has learned that he should not have put the entire IOTA account number on correspondence with Daniels. Yeah, IOTA account is interest on lawyers' trust account. It's an account that all attorneys have to have in private practice. When a client pays them, not when a client pays them, but when you get a retainer, I'm billing you $500 an hour. To start on your case, I need $20,000. You give me the $20,000. I put the $20,000 in the IOTA account. That's my account. And at the end of the month, I build, I don't know, 10 hours. 10 times 500, I can withdraw those funds from that IOTA account and move them to my personal account because I have earned those funds. Every attorney only has one IOTA account. Those funds for all of your clients get deposited in that account, and it's the attorney's responsibility to keep track of what funds are what. So he learned that he should not have put his entire IOTA account number on correspondence with Daniels, which he believed resulted in the account being compromised. He also did not know that he only needed one IOTA account rather than a separate account for each client. Bruh, really? That's like the first thing you learn in law school. He now knows that he must immediately take out any fees out of the IOTA account and cannot commingle personal funds with client funds, and that he should have removed $5,000 that he mistakenly deposited into a client IOTA account once he realized that it was in there. He should have informed both of his clients about the withdrawals, but he informed only one because he thought she was the one paying his fees, and he did not think he needed authorization from client A to get fees from client B. He also did not think he needed authority to withdraw the $5,000 that he mistakenly deposited into the account. Ridiculous. Prior to the hearing, respondent paid $42,000 out of the $47,000 in writ payments that he collected, $2,000 in April and $40,000 in September. He testified that in his practice, he does not have to hold clients' funds and no longer handles transactions like the one that led to this misconduct. In aggravation, he testifies that he was remorseful. I'm not going through this whole thing, but it was really a bunch of lies. He literally didn't learn anything from what he did because he was completely disingenuous. In aggravation, and these are things they found that was not in his favor. In October 2016, respondent attempted to loan a former client $2,500 by withdrawing the funds from a client's IOTA, but did not complete the loan because the former client changed their mind. Respondent testified that the $2,500 he withdrew from the IOTA account for the loan was not the client's money, but rather his own, because the $5,000 that he had mistakenly deposited and then left in the IOTA account. He returned the $2,500 to the client's IOTA account because it was drawn from there. Prior discipline, no prior discipline. One of the things that they identified was, hey, like I said, this guy was freshly out of law school, but early on, he's starting his legal career down a terrible road. I said this in that video, and I'll link it when I went through his full misconduct and how he was disingenuous when he talked about his reason for doing that stuff back in the day. He was lying like hell, and he was clearly disingenuous. And in that opinion, they even say that he was disingenuous and some things were kind of sketch. But most people, I don't know, most people though, when you go into private practice out of law school, the very first thing you do is you find a mentor, or because you need an actual office space because you can't have a PO box tied to an attorney's practice, you get in some type of office share agreement. I know, I did it. Hey, I'm new, fresh out of law school, I'm taking on clients. Yo, if you let me use some of your office space and supplies, you can have my services for whatever. I give you 16 hours a week where, at my disposal, it is what it is. I don't pay any office things. I'll give you 2 days of free work. I'll knock out whatever I need to do in the 3 days during the work week and the weekends. And those are kind of the transactions. But you got somebody there to kind of show you the ins and outs of what to do, the pitfall. So he started off on an absolutely terrible foot. That was in 2012 to 2015, but he was new. So the court was like, you jacked up. You ate up like a soup sandwich, as they say in the military. But because you were so young, we're going to give you some deference. Fast forward. Let's go ahead and pull up this article. This is the how many mistakes did Max Solomon make show. So let's go ahead and pull this article up. This is an article from December 31st. I talked about it in a previous video. Thornton Township 2025 ballot set by electoral board court challenges remain. Now, when I read this, something jumped out as being egregiously wrong and a mistake that should not be made from someone who's been practicing since 2012. That's over a decade, my guy. Like, it's crazy. So let's go and read the article since it's relatively new. We get up to speed. I talked about it before. All right, with the Thornton Township Hall in South Holland still closed due to lack of insurance coverage, 2025 ballot challenges were instead resolved at a South Holland restaurant. Township Supervisor candidate Nate Field, Sidney Moore, and Stafford Owens and trustee candidates Felisa Martin were knocked off the ballot. The Electoral Board decided December 17th, with written decisions handed out Monday. Objections to Supervisor candidate Harvey Mayor Christopher Clark and trustee candidates Kareem Davis, Jacina Golston, Dominique Randall L., and Rachel Jones were overturned. Effective candidates expressed frustration over the board's decision to strike certain names from the 2025 ballot, including Moore, whose campaign for township supervisor was grounded by religious faith, connections to the business community, and an interest in fostering fiscal responsibility. His removal from the ballot was approved unanimously because he had too recently switched his party allegiance from Democrat to Independent. Moore said Monday he thinks the Electoral Board members were unable to make a fair decision surrounding the candidate's eligibility and said he will appeal the decision in Cook County Circuit Court. The electoral boards were made up of various elected officials, with the supervisor candidate challenge board chaired by trustee Chris Gonzalez, who is seeking re-election himself in 2025 as a Democrat, and the trustee challenges boards chaired by Supervisor Tiffany Henyard. I think the decision to sustain objections was biased with conflicts of interest, Moore said, when it comes to unfairness and expecting nothing less. Gonzalez, who was unavailable for comment Monday, previously said he does not believe himself to be in the best position to offer an unbiased ruling on candidate objections and would have supported a more independent process for deciding who should remain on the ballot. You don't want to get any kind of personal thing involved in the decision, Gonzalez said after the December 17th hearing. You just kind of keep it as straightforward as you could, just like you were on a jury or something. Henyard was absent from Monday's hearing as she herself was in court challenging the result of a caucus that named State Senator Napoleon Harris along with his slate that includes Gonzalez as trustee, the Democratic nominee for supervisor. As it stands, township residents will only be able to write in Henyard's names if they want to vote for her during the spring 2025 township election, which is pretty much guaranteeing her a loss. Cook County Judge, this is the important part, all right? Cook County Judge John Michael Allegri said Monday Henyard's attorney Stephen Solomon submitted the lawsuit to the wrong court division and that he needed to transfer all documents from the elections division to chancery. Allegretti said he normally hears challenges from electoral board decisions based on whether the electoral board follows specific rules. But he said Solomon was asking for a determination that the caucus process was unconstitutional. You want someone to make that declaration, he said. That's what a chancery court does. Solomon previously mistakenly added Dixmoor Mayor Fitzgerald Roberts as a plaintiff to the lawsuit, requiring him to file to remove him. Meanwhile, Henyard called for a special meeting, blah, 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 blah. Okay, so in 2012 to 2015, you were making rookie mistakes. We can really generally give you a pass on that. Like, yo, you were kind of young, green, wet behind the ears, Similac on the breath, didn't know what the hell you were doing. But now it's 2022 and you're filing things in the wrong court. And when it comes to court filings, it's the easiest thing not to mess up, because even if you don't know, and I actually looked on the website, it tells you what each division within the courthouse handles. But even if you were unclear because it was ambiguous and you couldn't make it out, literally you call the clerk. The clerks are an attorney's best friend. Can't find a file, call a clerk. Trying to file something and it's 5:02, you need to get it in before 5 o'clock, a clerk will help you out. Clerks are the go-to. You can literally call and be like, yo, I'm filing this case to do this. Which is the proper division of the courthouse I should file it in, A or B? They will tell you specifically what the right answer is. And then when it's like Administrative Assistance Appreciation Day, you like bring the clerks a gift card or something so they can get food for the office, or you bring one of them edible arrangements with warm pineapples that people tend to love for some reason or another. That's what you do. So he could have went to the clerks, but he filed it wrong. Now let's fast forward to a recent decision that came out. It was interesting because actually, no, okay, let's talk about Tiffany Henyard's lawsuit over the caucus in general. It was in the wrong court. It was moved to the correct division of the court where it needed to be. So now that it's in the right place, we're talking about, was the caucus fair and proper? What are the issues? Well, she didn't have a full slate on her ballot. That was the biggest issue that she couldn't get over. But I don't know. Like, I'm not a electoral process expert, but the caucus was fast. It could give sketch vibes, but I don't know. Let's go ahead, tune into this video, find out what the court found, how the judge took a nice judicial bitch slap to Tiffany Henyard, and more importantly, her attorney, and get another chuckle at attorney Max Solomon and his inability to do the most basic of things correctly. That's the worst part. The things that he is doing wrong, like if you were making like a legal argument with like extremely bad law that wasn't even valid no more, I would be like, wow, that's actually terrible and egregious. But the things that he's done consistently, not communicate, pulling out funds that he didn't earn, like these are things that it doesn't even, the things that he mistakenly get wrong aren't necessarily related to the practice of law. Like real talk, law clerks file paperwork with the court. If I draft something, I'm like, hey, file this for me at the courthouse. They're the ones who do it. So like, it's not even like, I can't even, his legal arguments, that's not even an issue. It's just the basic things that are 101 that he continues to drop the ball on. So let's take a listen to what they had to say. And this is 1 hour old. So let's check it out. And I think it's quite interesting and quite telling of our guy, Solomon.
Development in the saga of embattled Thornton Township Supervisor Tiffany Henyard. A judge has dismissed her lawsuit, claiming that a caucus that threw her off the ballot was illegal. NBC5's Regina Waldrop has been following this case very closely for a very long time. She joins us now with details. Regina.
Marion, it is official. Tiffany Henyard is off the ballot for Thornton Township Supervisor, a role she was appointed to in 2022. Now, today, a Cook County judge ruled she didn't file her lawsuit properly, and he dismissed it without prejudice, meaning she cannot refile. So I want to take you back to the scene December 3rd. That is when Tiffany Henyard was thrown off the ballot. It was a packed and raucous meeting with an overfull crowd waiting outside. At that time, Henyard called it unfair and illegal. She said none of her supporters were let in to cast a vote. Now, we spoke to elections expert attorney Bert Odelson, who tells us the caucus was legal, and also a Thornton Township resident who says it might have been legal, but it might not have been ethical.
I think that they used some plays out of Tiffany Henyard's own playbook. They booked a venue that was too small to hold everyone who wanted to attend. They seated their own supporters early.
Were there, conducted the caucus, it was done legally. Even a properly filed objection wouldn't have stood. So she's done.
Tiffany Henyard's only option now is to be a write-in candidate in Thornton Township's April 1st election. Today's court ruling in no way impacts her role as Dalton mayor. She remains the Democratic nominee in that contest, but she also is facing a number of lawsuits and financial investigations. Next Monday evening, former Chicago Mayor Lori Lightfoot will release her second report on financials at a public meeting at the Dalton Park District. And we've reached out to Tiffany Henyard's attorney, but we have yet to hear back.
That might be the very first thing that happened that I will actually live stream, because that's actually interesting. I'm never going to live stream the trustee hearings. Nah, your boy ain't built like that. I don't got the bandwidth to do it. But I'm actually probably going to make sure I'm on early, because that's something that I would actually live stream, because that's going to be interesting. I want to rewind it back to the beginning though, real quick, because I want y'all to hear the most important part of this. And then we're going to talk about ineffective assistance of counsel with regard to Max Solomon again, and how he may be the worst attorney that I have ever seen that has over 10 years of experience.
Illegal. NBC5's Regina Waldrop has been following this case very closely for a very Henyard. A judge has dismissed her lawsuit, claiming that a caucus that threw her off the ballot was illegal. NBC5's Regina Waldrop has been following this case very closely for a very long time. She joins us now with details. Regina.
Marion, it is official. Tiffany Henyard is off the ballot for Thornton Township Supervisor, a role she was appointed to in 2022. Now, today, a Cook County judge ruled she didn't file her lawsuit properly, and he dismissed it without prejudice, meaning she cannot refile.
The dude filed the lawsuit improperly. So whatever her arguments were, never even got heard. Nobody give a damn about what was in the pleadings, what was in the document, because he couldn't even get over the very first hurdle of filing the lawsuit properly. So with that being said, I'm going to assume this is just me. I'm going to assume that he filed the lawsuit with the wrong name. He filed it in the wrong division. Then he refiled it, and then he filed it improperly, and it was dismissed to the point where it can never be brought back again. And I think the judge did the right thing there, because I'm tired of this shit show. It's almost going to come to an end, so I'm not going to do anything to prolong this battle or waste any more judicial resources. But when you don't even allow your client's argument to be heard, even if it's an ass argument, okay? Like every argument in every case you have isn't going to be a great argument. Sometimes you have to argue with what you have to work with. Like you go in like, yo, I'm going to keep it a buck with you. This is not the strongest case. If someone said, sell me a case that you got that's a winner, this would be near the bottom of the list. But you have to make an argument. When you don't even get over the filing process to have them actually even read your argument or consider it, that's just legal incompetence on my part. Filing a lawsuit in the right place is not rocket science. You know how many people, like literally, I've been a defense attorney, and people have filed lawsuits properly. People have filed appeals written on notebook paper, written on a long ass sheet of toilet paper. I saw a guy, he filed a notice of appeal, and that thing was written on some like doo-doo paper. I was like, nah, we'll take your word for it, clerk. But it was literally written on a long ass strand of toilet paper, and it had the case number, all the proper spacing and alignment, as if it was a typically written legal pleading. But this is incompetence at the highest level, not to be able to get over the hurdle of just actually filing the case. So we're going to talk about a case. Strickland versus Washington is a Supreme Court case in 1984. So this is a long time ago. And I know, like, oh man, this dude talk about cases. But Strickland versus Washington is an important case because it's the case that sets the standards for what ineffective assistance of counsel is. So I just want to pull it up so we can see it, and it's consistent across the board. Y'all know anytime I talk about something, I talk about it at a federal level, but most times, 90 some odd percent of the time, state statutes mirror federal statutes and guidelines. We saw that in the video I did when we talked about the 412 rule of evidence, same concept. So even though this is a Supreme Court case, it has implications to the state level. So the law is still good. It's still good law. Let's go and pull it up just so you all can know what the standard is for ineffective assistance of counsel and make a determination if that standard was completely not met with Max Solomon and his inability to file lawsuits in the proper divisions in the court, then to file it properly once he tried to refile it in the proper place. All right. Strickland versus Washington, Supreme Court case, primary holding. And we're not going to go through all of this. Hold, let me see if I can see. This might be interesting. It's a little nerdy, but I'm going to read the summary of it so you can get it, so you can know what this case was about. But this case is what established when a lawyer sucks ass so bad that it was a miscarriage of justice. All right. The respondent pled guilty in a Florida trial court to an indictment that included 3 capital murder charges. In a plea, respondent told the trial judge that although he had committed a string of burglaries, he had no significant prior criminal record, and that at the time of his criminal spree, he was under extreme stress caused by his inability to support his family. The trial judge told respondent that he had a great deal of respect for people who are willing to step forward and admit their responsibility. And preparing for a sentencing hearing, the defendant's counsel spoke with respondent about his background, but did not seek out character witnesses or request psychiatric examination. Counsel's decision not to present evidence concerning the respondent's character and emotional state reflected his judgment that it was advisable to rely on the plea for evidence as such matters, thus preventing the state from cross-examining the respondents and from presenting psychiatric evidence on his own. Counsel did not request a presentation report because it would have included respondent's criminal history. Long story short, this attorney failed to do things that would have mitigated the client's sentence. The first thing you do when you have a client who you think might be kind of out there, might be a little, you might want to put a red X on their file. So if you're not in, somebody know that this is a special individual. You want to get a forensic evaluation. This client had issues. The attorney failed to do any of those things. Some of those things could have mitigated the sentence that he got for the plea that he entered. The holding from the court was simple, and it says the appropriate standard for ineffective assistance of counsel requires both. So it's a 2-part thing that needs to be done. The attorney was objectively deficient. Do you all think an attorney is deficient in their job if they can't file a case properly? Yes, that's like not being able to file a case properly is like, it's like being a burglar and you don't know what a door is or window is. Like you just standing there staring at the bricks to the house, like, all right, with a crowbar. Like it's literally the first step to do what you want to get done. So the first part is, was the attorney objectively deficient? And the second part is that there was a reasonable probability that a competent attorney would have led to a different outcome. Very, very low standard. I think we can all see from that holding, I think that we can all see from that court's holding, ineffective assistance of counsel is a very low threshold. I'm just going to be honest here. This dude repeatedly filed things incorrectly in the wrong place or in some manner of deficiency that didn't even allow his client's case, even though that case may have been aspirin, didn't even allow his client's case to get heard. And now it's dismissed and his client has no recourse to bring it back in. So I don't know if she paid him. If she did pay him, I hope it wasn't a lot. honestly, this type of work is not deserving of any compensation. And if she did pay him, I pray that it was out of her own money and it wasn't with the township funds. But let me go through and check out some of the comments. I know I've ran on for a long time, but I wanted to get all of the stuff out of the way before I hit the comments so we can jump in. Let's see. Oh, they lost the. So they lost the. Yep, the judge tossed out the caucus lawsuit, and they lost the case on the business licenses where they purportedly were trying to shake down people. Yeah, hey, I'm telling you, we all over it. Let's see. Max should be Miss Cleopatra. Hey, shout out to hey, that's a interview, bad counsel. Hey, I don't know. I don't know. I was gonna say let's give her a chance to redeem herself because she said she's gonna have an opponent of Tiffany Henyard on. I don't believe it. I'm not gonna believe it till I see it. But shout out for bad people need bad lawyers. Bad people need good lawyers, but in this case, whatever. Bad people having bad lawyers may not necessarily be a bad thing. Shout out to the township for getting the new supervisor and things turning around for him in 2025. Yeah, they are like the movie Dumb and Dumber. Then the sequel, Dumb and Dumberer, is straight Lloyd and Harry. It's straight Lloyd and Harry action going on. Yeah, I understand that Tiffany lost a lawsuit against Napoleon because Max filed the raw claim. Somebody needs to disbar Max. And this dude is running for mayor somewhere. Like, I don't know, bro. If you can't even file a proper lawsuit, like, I don't know, man. Like, I don't know. What's going on, Aaron? I appreciate you tuning in. Let's see. Hey, I appreciate you, Lady Luck, for catching the live stream. Hey, DMV, let's get it. Let's get it. Shout out to Foxy, 2, Roxy, 3. Let's go. Hey, we about to get this. We about to go to the bowl, y'all. I don't know if y'all know that. Yeah, he's definitely incompetent. And like, it's sad to be practicing for over a decade and still need a mentor to do basic stuff. Sounds perfect for Tiff. You get what I want to know what the agreement is, what the compensation is. He can't be doing this for free. Like, if this dude is doing it for free, Max Solomon may be independently wealthy. Because I don't know what other job. Now I'm about to look him up on LinkedIn. now I'm about to look him up on LinkedIn. Let me see. If I look it up on there, it'll jack up. Let me see if Max Solomon is on LinkedIn. Why didn't I do that? I look at everybody else LinkedIn. I didn't even think about that. If he on LinkedIn, I'm gonna pull it up on the screen. Hell no, I see a lot of. Let me see. Okay, I see. Nah, bro ain't got nothing. He on there, but he not active on there. It says Max Solomon, attorney at law, adjunct professor at South Suburban College. It don't have nothing for experience. It's just a pretty much there's a profile that look like he created and he may not have done anything with. So I don't even know what he does to maybe is he still employed at South Suburban College? I don't know. But he has to have another job or he's independently wealthy because this type of bad lawyer is not worth adequate compensation to allow you to not eat top ramen, although ramen is fire. Shout out to top ramen. I'm just saying, yeah, it's the court rules that he could Google. I agree. Most times, a lot of courts have it on the website, like how to file a lawsuit, and they have everything literally spelled out for you because there are a lot of pro se uh, plaintiffs. There are a lot of pro se defendants who don't have attorney, and they just unilaterally doing it on their own. Yeah, he could have called it. He could have phoned a friend. Hey, but shout out to you. He could have done anything but what he did. Like, and the other thing that's weird, like, I'm gonna tell you, this is really weird. Like, this is a saying that I made up. I'm sure I'm not the first. I'm not the originator of it, but as it relates to attorney to client, my saying is, I know what I know and I know what I don't know, but you'll never know what I don't know. Does that make sense? So if you're my client, I generally know enough about most aspects of law to talk about it on a level higher than a person who isn't an attorney. But if it's something that I don't know, you are supposed to put your little buffer caveat out there. If someone asks me about, let's say, something related to family law. Like I would loathe to do family law with all that drama and guys repeatedly getting raked over the coals. Some deservingly so, some not. But yes, I digress. I would never do family law. I'm not a family law expert. I would say something to the effect of, well, family law is a very interesting area of the law because there are gray areas. It's not like bankruptcy or tax where there are clear do's and don'ts. A lot of times the courts rely on a concept called what's in the best interest of the child, and that determination is solely evaluated by the judge. But let's schedule a time to talk so I can get more facts about your case, and then I'll let you know what's the best avenue of approach so I can represent you and make sure your interests are satisfied and met. But so you give some fluff like that, I don't know what the fuck you're talking about. I said the one thing that I know generally about family law, I'll figure it out and get back to you. It's very simple. You should never let your clients know what you don't know. You know what you don't know. You should never let generally anyone know what you don't know. And if you do let someone know what you don't know, you should have exhausted all of your options before you got to a point where you got to be like, yo, bro, I looked and I can't figure it out. But I don't know. It's just a weird thing. You like, I remember once I had a trial and I was a defense attorney. This was maybe like year 2 or 3. So I'm relatively new. I might maybe year 2 or 3 because I was new, but I had a handful of trials under my belt. And it was 2 defendants. I was representing one, another guy was representing another. We wanted to do a motion so we can have these trials separately, but the judge was like, nah, that's too much time. Excuse me. So we had to do them together. And I remember our clients in there, we go out in the hallway, and this attorney just taps me, and he was like, I never had a trial before, and I've been practicing for 4 years. Can you please help me out? And I was just looking at him like, bro, whatever you do, wipe that look off your face and just object to shit you think you should object to and use all the basic stuff. But this dude went 4 years without never having a trial. And at least he didn't tell his attorney. I'm sure his client probably thought this dude had a plethora of trial experience. So you never let your clients know what you don't know and you ask to get instructions. Isn't that simple? And Lady Luck, you are right. Google, I said it in another video. If you don't start your legal search with Google, I don't know what's wrong with you. If you're on Lexis or Westlaw doing some other in-depth legal research with a book before you Google it, you are doing it completely wrong. It's 2025. I'm not saying use AI, but Google is a really good place to start your legal research at. Yeah, Max sound like Mr. Magoo, just a lovable loser. That's it. He also filed complaints that were not verified. This dude just like it's like Halloween and he's going as an attorney. Like this dude just like I don't know. He just out here like he doing it for play and it's crazy. Yeah, the Republican caucus was fast. I did see the video of that. It was literally like the polar opposite though, but it was fast as well. And just because something is expedited doesn't mean that the process is flawed. So I think that's a fair point, Lady Luck. Just because something is fast doesn't mean that it's not done correctly. Look, I was about to say a bad, inappropriate joke, but just because something is fast doesn't mean it wasn't done wrong. Y'all get what I'm saying. Tiff might be okay. She can file a malpractice claim against Max. Max Solomon might be independently wealthy because I don't know, like, even if she files a malpractice claim, like, I don't know what he does. If he's still working at South Suburban College, that's cool. I don't know what his financial situation looking like, but it wouldn't even be worth the time. I think she should just go off into the sunset after she take all of these L's and I don't know, do the good burger thing or figure out something else. Yeah. Yeah, I agree. Like I said, Just because it's short does not mean that the process was done incorrectly. I agree. Yeah. 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 He put that mayor's name on a complaint along with Tiffany. The mayor did not want to be included. Yeah, that was one thing. We was like, why would he be included? Then he was like, yo, bro, why you even file my name on that stuff? Solomon is inept and doesn't know the game. Yeah. And even if you don't know, I don't know. Like, I don't know. Like, and that's the other thing too. Like, bro, if you actually had like a good legal assistant, all of this shit would be taken care of. It would be all the court filings, filing the motions, filing everything. All you would do is just sit at a desk, draft everything out, proofread it, let your clerk or your clerk will draft it. Because some things are like when you file a complaint, no attorney. When was the last time I filed a document from scratch? It probably it probably was like 14 years ago, year one. Nobody files anything from scratch. There are so many samples of various lawsuits that are filed. You look at the sample, you find one that's kind of similar to your facts. You take out the mess you don't need, you put your facts in, incorporate it. So being an attorney and just filing the paperwork, the arguments, is very few arguments out there that are arguments that have never been made. So being an attorney is not reinventing the wheel. You know what I mean? We're filing cases that have facts that are similar to cases that have been previously filed, and we want to match our cases up with old cases that had the same facts that had the outcome we want. That's the name of the game. It's not rocket science. It's not like attorneys of neurosurgeons. No, it's just not reinventing the wheel. Yeah. Don't call Solomon. Hey, I don't know. That's a damn shame. I just want to get through these comments. That's what I'm thinking. I would like to know what Max does for a living. Let's see. Leotis out there still on goon duty. Everyone knew this about Max. Maybe he was the only lawyer who would take this. Oh yeah, or the only lawyer who wanted to get involved. Because for a minute, she had some real tight Caucasian white guys sitting with her, and after a while, they just left. They was like, nah. And once she had two white guys, like a heavy set guy and a smaller guy, and they just was like, nah, bruh, we're not dealing with this tomfoolery. So yeah. Yeah. That's why I was like, yeah, she did, but in any event, she can't bring it again. So, you know, kind of weird to Paul say that. Let's see. They didn't file the paperwork for putting the name on the ballot correctly. Complaint for the caucus should have been filed with the township first. Whatever it was done. Karen Johnson, I think he meant to do that. He's sick of her and scared to say, that's an interesting theory. Hey, how could you get out of something you don't want to do a bad job at it? Hey, hey, I don't know. Hey, that's an actual interesting take. He like, you know what? She getting on my last nerve. She won't let me sever this agreement. Like, hey, I don't know. That shout out to that comment. Hey, Solomon outsmarting us all, and like, yo, I would just keep filing shit wrong until she just fired me. Until she just fired me. I don't know. I mean, like, that's a unique take, but I would be very shocked. I would be very, very, very shocked if that's the case. That's a unique take, though, but I would be very shocked because you can always ask out of attorney-client relationship, and if the client don't want to fire you, you can just ask the court. Like I talked about that before. Anytime a client is getting on your nerves, or if a client is about to lie, or if your client is lying and you try to dissuade them and they like, no, I'm gonna get on the stand and lie, you just go in front of the court. When you want to get out of representing the client and it's something the client doing is jacked up, attorneys just go in front of the court and say, Your Honor, I'm asking at this time that Mrs. Henyard be allowed to seek new counsel. Currently, we're at an impasse as to strategy. Essentially, what that means is she either about to lie, she not paying me, it's some bullshit going on, Judge. You need to let me out of this case. We got enough time. Let's continue it to give her some more time to get an attorney. Because that's all the judge will care about. If you ask the judge to get out, if his case was filed properly, could he get out of this? Probably not, because time is of the essence. The main thing is the judge will normally let you out of the case if there's sufficient time for the client to obtain new counsel. Because elections are speedballing around the corner, he might have not got out of this because time is of the essence. Yeah. Oh, the electoral board she's 100% going to lose if people have to write her name on the ballot. I don't know. I think it's an interesting is an interesting thing. Yeah, no wonder Solomon was suspended. He doesn't seem to do his paperwork correctly. Yeah, and that's hurdle number one. That's like getting off the block in a race. Yeah, he has to be working. Okay, are we sure about that? He has to be working pro bono. He may just want some publicity. He's run for office multiple times. Yeah, he's running for the mayor of Hazel Crest, if I'm not believing. I think his name is on the ballot. I think he's 0-6 in elections. I looked at it's called a Ballotpedia, where they look at the electoral history of old candidates and current candidates. And yeah, he was habitually losing. He can't be doing this pro bono because it's, I don't know. He can't. He has to be getting some compensation. He has to be getting some compensation because it's two reasons. Three. One of the three reasons is a very bad reason, but there's three reasons that an attorney will generally do something pro bono. One, because hey, I genuinely want to help people. So like, sometimes DFD volunteer for the weekend, I'm gonna spend 4 hours helping people out, writing wills, basic stuff. If you got some complex shit, go hire somebody. But basic stuff, something like that, because you generally want to help. Or you've been in court. I've been in court and I've seen a guy stand up there with no attorney, and I was like, damn, this dude about to get screwed over without even a hug. Let me step in. Yana, I'm representing them for this limited purposes, blah, blah, blah. So somebody's about to get screwed over, or you generally want to help people. Two, you're doing it as a favor to a friend, which is the dumbest of the three reasons. Because if you have a friend, you probably shouldn't be doing it. I don't know. It's the dumbest of the three reasons. And I would never represent someone pro bono as a favor to a friend, because even if your services are good and you do it for free, they'll value anything that happens as shit. That's like if you have a product, like, yo, I got this product and I know I can sell it for 25, but I'm gonna sell it to you for 5 because you're my boy. They're gonna be like, man, this $5 piece of shit. But that's the worst reason. Like, if you want to really help your friend out, find an attorney who doesn't know them, is not personally interested, who can give them a reasonable price and represent their interests. You want to separate yourself and not be too close. So you generally want to help people. You're helping out a friend, all for publicity because it's very good press. Now, what would be an example of that? An example of taking a case pro bono where you're doing it just for the publicity would be, I'm doing a case of, let's see, I'm doing the case of something that's very newsworthy, one, and two, I can do this representation and not look like an imbecile. Those are the two prongs to when you want to take something that's newsworthy. Like, okay, it was the Duke Lacrosse lady who lied on the guys at Duke Lacrosse, Crystal Mangum. Crystal Mangum, she at one point after the lacrosse thing had like an arson. Crystal Mangum probably had zero money to represent an attorney. But because of the prominence in the Duke Lacrosse thing, her name was well known. It was going to get media attention. I could see why an attorney said, you know what? I'm going to represent her on this arson case for free. One, because I know what the hell I'm doing. Two, this case is going to get publicity, and media publicity for me is a good thing. And in that case, I think that arson actually got dismissed. So it worked out. Taking a case for notoriety only works when you look like you know what the hell you're doing. If like it's bad, like, yo, I'm gonna go represent Tom for free, and everything I do wrong, you look like an idiot. If anything, you look like an idiot, and the only idiot bigger than you is Tom. So like it makes Max Solomon look bad. And the only person who looks worse than Max Solomon is Tiffany Henyard. So he can't be doing it pro bono. If he's doing it pro bono, bro's wild. Even though he's not deserving of a large salary, he better be doing it for something. I don't know. I would love to see what the representation agreement is between these two. 3 times under Democrat/Republican Party. Yeah, that dude's wild. If he wins that election, there's no way he gonna win. I'm not even gonna say. I'm not even gonna insult the citizens of Hazel Crest by saying if he wins. I don't see any way in the world that he will win that. Yeah. I don't know. It's crazy. Let's see. I mean, I don't know, man. 12 years? You've been practicing for not 12 years, since 2012? How much brain organization do you need? I mean, come on now. And I know because my memory, I used to have damn near photographic memory. Now, not so much. Still good, but not photographic. And, I know about disorganization and all of that stuff. You're talking to somebody who had 3 brain surgeries, huge scar. I get it, but sometimes it's just attention to detail. I just don't think he pays attention. I just don't think he pays attention. And I think to have these type of mistakes, you have a lack of attention of detail. And I'm gonna just keep it a buck. You're probably lazy. You're probably lazy and not willing to do. They deserve each other. Is a match made in a match made in idiocracy. If that, if Max wins his election, that's gonna be wild. That'll be wild. I'm jumping on a live stream immediately. Oh, that's interesting. That's that's actually a good. Hey, real talk. That would actually be a funny video if somebody call and it's like if somebody call and like just get like what's his rates, what's his billable rates is, how much do he charge an hour? That would be hey, the other thing too is I'm gonna be honest. In order to practice law, you have to have malpractice insurance. But considering all these crazy stories, I don't even know if do y'all think Max Solomon has malpractice insurance? That's a good question. Oh, I'm sorry. Shout out to the family, Foxy 2, Roxy 3. Hey, I appreciate the super chat. I definitely appreciate it. How many more L's can we go through with super stupid? Like, I don't know. It's an indefinite number of L's that can be taken when we're dealing with these folks. So, hey, my bad for what? Hey! It's a phablet. It's a phone and a tablet. See, I bought it with a particular purpose, right? Prior to I don't know, like it comes in handy. Normally I just use it this way, but it comes in handy when I have to read documents or sign something or reply to comments or trying to do like that. And my fingers they ain't like I don't got like sausage links for fingers or nothing, but when it's like this, sometimes I hit the wrong thing and it look all grammatically incorrect. So yeah, I got a phablet, okay? It's a phone, it's a tablet, it's the best of both worlds. Don't hate. I got a phablet. Yeah. All right, let's see. Yeah, what could he possibly be? Yo, shout out to somebody look on the website, South Suburban College. What if he teaching like criminal procedure? Oh man, that's hilarious. Yo, y'all hilarious. Hey, shout out to my guy Kenneth Dawkins. Yo, Y'all are cracking me up. A round of applause to you. But that's a funny ass comment, man. Like, now I do want to know, like, what is he teaching? What did he teach in South Suburban College? Oh, y'all got me rolling, man. Y'all are on one tonight. That's wild, man. I was the judge was asked Solomon how long he's been paid, but he's done billable hours. He probably billing a couple $100 too. That's funny. I'm gonna hit up some of these comments and I'm gonna jump out of here. 4 years with no trials. Why did they motion for expedited hearing? COVID era. Now this was pre-COVID here. It wasn't the defendant was sitting for 4 years without a trial. It was I was representing the defendant. He was representing the defendant. We couldn't get the judge to agree to bifurcate the cases, so we had to try it together. So we're both sitting at the table. I'm making objections for my client. He's making objections for his client, and he was practicing for 4 years and never had a trial. And that's actually pretty common. Like if someone goes to a law firm, for probably 2 or 3 years, they just doing, I'm not going to say flunky work, but I'll say they're probably just doing a bunch of research and writing. Yep. I appreciate everybody, all y'all for tuning in the chat. He said other side of office Google. Like, I mean, if it's I don't know. I've been doing what I've been doing for so long. Is very rare instances where I like, this is a unique issue. But I do come across issues that are unique. And I'll start by saying, let's see what courts have to say about this and look across the board. So, but if your doctor Googling some shit, doctors probably doing the same shit. Like they probably doing the same shit. Like and Googling, hey, I had a jaw pain one day in my left jaw, and I was like, yo, is it a dental thing? What's going on? And I woke up with a jaw pain. Now, unbeknownst to me, it was a sinus infection and sinus pressure in your ear, it'll feel like it's a pain in your jaw. I didn't know that. Man, I Googled left jaw pain. And as soon as I Googled it, WebMD came up. It was like stroke. I was like, stroke. I went to the emergency room. I was like, hey, doc, I don't know what's going on, but I went on WebMD. I Googled it, and WebMD said stroke. So, yeah, if your doctor Googling something that's wild, generally don't Google health stuff. Because I went to the ER. I was like, nah, y'all about to go in here. Hey, I'm a vet. Hey, I'm going to the VA emergency room. Y'all gonna do everything y'all. Yeah, get all my vitals. Make sure all my shit look the same as it did 2 years ago. They thought I was crazy, but hey, look at that our LinkedIn profiles. I mean, hey, that's where you got to start, man. Like it's 2025. I just told somebody I was at a restaurant picking up some food, and this lady was telling me her daughter wants to go to law school. And she wants to go to my alma mater. And I was like, oh, that's interesting. And I happen to sit on a committee for finding interns. So I was like, oh, that's actually interesting. But, it was funny because, let me see. Is the blind leading the blind? Yeah, I agree with that. But I don't know. It was funny because I was like, yo, is your daughter on LinkedIn? And she was like, no. And I was like, it's 2025 and they're in college. How are they not on LinkedIn? Like, I've seen jobs where they don't even want an application. They just like, put your LinkedIn link in this and click enter. That's the application. So yeah, everybody I think it's good for everybody to have a LinkedIn profile, unless you got like warrants or something like that. Hopefully you don't got any of those things yet. She can still flip burgers, but a good burger though, like that was not an original idea. Like even the name, bro, like that wasn't an original idea. Like I don't know. Kumo Maloney. Karma came back on her real hard. Yeah, she's just getting her ass whipped right for. But hey, it's nothing. This is actually the best thing she can do. I think is just be quiet. Yeah, it's gonna be, man. It's just I can't wait to see losing a $300,000 income. I don't think y'all understand. Like a $300,000 income. How long y'all think y'all could go if y'all took a 50% pay decrease? 6 months, a year? Like, hey, losing a $300,000 income to $100,000, like, unless she was like a financial guru, which I seriously doubt, like that shit'll, even if she got a job making $100,000, unless she was one of the best financial people and fiscally conservative people, she gonna be fucked. Is no way in the world. Yeah, that's fair. You're saying that is not malpractice, is like a in torts. If I have a sign and say, please do not use this restroom, use the other restroom. This restroom is flooded. And you go in there and use that restroom because the other one is full. And when you flush it, a geyser come out and you get fucking injured. Your argument is, well, it's not malpractice because you kind of knew he was incompetent beforehand, so you assume the risk. You know, that's in torts law, that's a valid defense. Well, yeah, it was a risk, but you assumed the risk because the risk that you took was made aware to you and you chose to take it. Interesting. Eh, I think that the issue with that is the expectation is that an attorney has the minimal standards of what's needed to engage in the practice of law. And I think the first step of minimal standards is you can type up a complaint and you know how to file it in the right place. That's what I think. But that's an interesting argument. Can you assume the risk if you have evidence of prior imbecilism of prior imbecilism by counsel? That would be a crazy argument to make. Could you imagine making that argument? That you should be disbarred if you make that argument. Yo, Your Honor, I am not guilty of malpractice because she assumed the risk. I was fucked up for a long time. That's a crazy argument. That's a crazy argument. If you make that argument, I would disbar you immediately. I think that's a good point. I don't know if the money's coming from her. I pray that it's not coming from the township. Yeah, that's true too. That's true as well. That is true. Hey, shout out to you, Lady Luck, co-counsel. Yeah, I did a story early on why when they jumped out of it because attorneys weren't getting paid, and like I'm just telling you right now, it's only a certain type of attorney is going to stick around if they aren't getting paid. 99.9% of them are going to get the hell out of Dodge. Hey, I don't know. Like, yeah. They make a movie, they need to put that. It should be like, nah, I don't know. I was about to say they gotta put that shit on Tubi. They gotta put it on Tubi or something, but that'd be hilarious. I agree. Repeat it. Repeat it. Let's see. The fact that she was trying to convince the Democratic Party to appoint her to a Cook County commissioner position, to me, it shows that I think that I'm be honest, I think that she's aware that she has the inability to demand a salary anywhere near what she's currently making on the private market. I think that's what it is. Because like, I mean, like literally most politicians when they lose elections, they go and slide right into a job in consultant where they probably make 2 or 3 times what they were making as a politician for at least 3 or 4 years, because statistically, that's how long your contacts last. Yeah, I seen her at one press conference and then she never showed back up. I seen that lady at one press conference and I never seen it again. Yeah, that is apparently apparently according to the chat, I haven't seen the documentation of it, but it said that that was a sanction that was issued by the court. The court was like, "Bro, don't come in here unless you come in here with a tutor." Nah, not a criminal defense attorney, and I do not practice in Georgia. Nope. Let's see. That's insane. I Interesting. Jack can't cook. I'm familiar with who he is. Oh, I mean, I don't know. Hey, he looked like he had some promise, man. I don't know where he went astray. And honestly, sometimes just some shit you want to do, it ain't in your destiny for you to do it. Like sometimes you gotta realize, like, yo, whatever path I took, it may be a time for me to pivot. It may be a time for me to pivot. Like, I don't know. Like at this stage in your career as an attorney, like someone was talking to me like, "Oh man, what are you thinking about retiring?" And I was like, I don't know. Like at this stage, when you got like 15 years in as an attorney, unless you just said, "I'm switching and I'm going into a whole new practice area," once you got 15 years in, you don't have to research as much because you've seen it so many times. Like it literally, it like most things. If you're a mechanic replacing a alternator in year 1 versus year 5 or year 10 is going to be two different things. So it shouldn't get harder and more difficult. I don't know. It shouldn't get more difficult as you age in any career. You think it would get easier? Yeah, he doesn't know this country language. Hey, that's fair, but if you were able to graduate law school and pass a bar exam, like I'm just saying, welcome to Good Burger, home of the Good Burger. I seen one of those burgers too. It was I can't think of the trustee's name. What is his name? He kind of looked like, I don't want to be disrespectful. Dark skinned guy, tall, bald head, like kind of droopy eyes. Man, his name escapes me, but I saw a picture of him eating one, and that burger did not look appealing at all. I don't know. That burger did not look. It didn't look good at all. I was like, ugh. I can't remember the trustee's name who was eating one, but yeah, that burger. I see him eating it, and I was like, what the fuck is that? What the hell is that he holding in his hand? It looked crazy as hell. Let's see. Let's see. All right. So before we get out of here, that'd be terrible. They should start a law firm together. I wonder, is Illinois a state where all partners in a law firm have to be attorneys? Because some places, like in North Carolina, if you're a partner to a law firm, you have to be an attorney. But like in Los Angeles, you don't. In New York, a non-attorney can be a partner in the law firm. They just can't do like courtroom shit. Clearly, that's insane. All right, real quick before we get out of here, I'm actually really excited about Monday. I'm really excited to see the follow up to the investigative report into Tiffany Henyard's spending that's going to be done by Lori Lightfoot. I think that's going to be the first and probably one of the only like actual live streams that I'll do. So I'm gonna make sure that, hey, I'm off the 9 to 5 clock a little early so I could get my popcorn ready and we could tune in and see the shit show beginning. I'm interested to find out the only thing I have, and I will sign out after this. I'm interested to see what Lori Lightfoot report says because this is the more detailed version. She said the first part she said was a preliminary finding, but I don't know. One thing that it never made sense to me. Normally, when a city council or trustees in this example, when they hire a third party to conduct an investigation, well, normally it'll be a state entity, but sometimes they'll go out and get an outside third party because they want it to be objective, and that makes sense. If it was a local entity, you couldn't trust the credibility of the report because Henyard does have her thumb on a lot of things. So, but normally when you get an outside third party, the council gives them the ability to have some type of subpoena power. For instance, look at the federal government. When Jack Smith did his investigation into the president, the Congress was like, yo, you can investigate this. And by us voting to allow you to investigate this, we give you the ability to be able to bring in witnesses and do these things. So not having subpoena power is interesting to see what the findings are and how detailed they're going to be, because I'm telling you right now, if I were an attorney for Tiffany Henyard, Max Solomon, but if I were any other competent attorney for Tiffany Henyard, if she came to me asking for any documents, I would just tell her no. Like, I'm under no legal requirement to give you anything because you don't have any subpoena power. So why do I need to give you anything? When you come to me with a subpoena, I'll give you what you need. But until then, I'm not giving you anything. And I looked it up to see if the trustees voted and something to give her this ability to be able to subpoena records and conduct interviews. And I didn't see anything like that. So I'm interested. I don't know how. I've done internal investigations on high level government officials, and the only way the investigation was able to be done in an effective manner, it was because people had to cooperate. If they didn't cooperate, there would be huge sanctions. Without that, I don't know how you get the information to really build an in-depth investigation. Like let's look at the preliminary investigation. Oh, we know she spent $40,000 at Amazon. If you had subpoena power, we would have known exactly what the fuck she bought from Amazon. We'd have been like, yo, she bought 2 portable blenders, Nino Brown hat, a stuffed Rottweiler. Like, we would have known exactly what it was. So I'm interested to see how that whole thing plays out. Yeah, that's who it was, Stan Brown. Hey, shout out to you for co-counsel. Y'all always come through in the clutch. Let me see. I shout out to y'all, but it's going to be interesting to see how things play out Monday. Tomorrow, hey, I'm probably not going to do a live because my little man going back to school. Thank God, this dude had the longest fucking winter break ever in my life. I love him, but I'm like, bro, my grocery bill went up exponentially. It's just ridiculous. But me and him going to kick it tomorrow, so I probably won't do a live tomorrow. Yeah, I might get something Saturday, depending on, if I don't really care about Saturday's game, clearly. But I don't know. We might do something if something interesting break. I got a few interesting videos about Mayor Shang Tao, who was indicted and is facing 95 years in prison. So I got some stuff I'll put out for y'all. I appreciate everybody for tuning in. Let me take a look at these last ones. Yeah. Lawyers receiving information. No doubt about it. Yeah. These workers scared. And that's a reason. But the question is, can they compel it? Can she compel it? Like, I agree, though. Like, people are probably either scared or they're just so fed up. Like, yo, just take this shit. I don't give a damn if you need a subpoena. What you need? I don't like her. Here you go. Yeah, she told me to do it. She ordered 15 pair of sandals and some lace fronts. Like, nah, I'm messing with y'all. All right, yeah. It's gonna be more shocking than we know. Yo, we're gonna be in there for it. We're gonna be live. I'm sure a bunch of people are gonna be live streaming it. So hopefully y'all can join me. I'm gonna try not to talk as much unless it's just some goofy shit like like, yo, she bought like 16 so if it's something crazy, but I'm gonna not talk as much because we gotta be able to hear the report. And then maybe on the back end, I might give a little commentary. So y'all might see me eating a sandwich or something because I'm gonna have to do it straight from work. I don't even know if I'm gonna have time to get out of my work attire. But that's it. I appreciate everybody for tuning in. Hey, as always, I'm appreciative. I'm grateful. Actually give me energy, and I enjoy coming to do this thing. So I'm appreciative of y'all. I'm very grateful, very blessed. If you enjoyed this, make sure y'all like, share, subscribe, comment. Y'all take care, and more importantly, be warm out there and be safe. Peace.